Hey guys, welcome back to the channel, and today we're going to be reacting to
NewJeans Once Said trial was unnecessary. Why did they show up in court in funeral attire? We did the news thing, with the NewJeans court, but this is the lawyer. So
mm-hmm.
let's see what the lawyer has to say about
Yeah.
this.
Today, I have prepared a detailed review of the first hearing in the ADOR versus NewJeans provisional injunction case. In particular, the statements made by the NewJeans members in court have been revealed. This is a crucial point in understanding the stance NewJeans is taking in this trial. Let's take a closer look at what messages the members conveyed and how this case is expected to unfold. Don't forget to subscribe,
Mm.
like, and turn on
Wow,
notifications.
we have
Now
a
let's
lot
get
of
started.
opinion.
Part 1.
Well, I'm hoping this is going to be not an opinion, but more like a legal analysis. Because
Yeah,
opinions,
yeah,
we've
yeah.
seen those. Like, I want to,
Mm.
like,
Especially from his perspective to say culturally
right.
speaking.
Yeah. Like, I want a confirmation basically. Are we
Yeah,
right or are we wrong?
yeah.
Change in NewJeans' attitude from the November press conference. First, it is important to analyze the significance of the final statements made directly by the NewJeans members in court. Among them, special attention should be given to Danielle's additional remarks at the end. Danielle declared, "No matter the outcome, we will never stay with ADOR." This statement carries significant weight, as it was made with strong emotions at the very end of the trial. One, comparison to the November press conference. Since NewJeans' press conference in late November, several months
Yeah, in November they said that, oh, that you have to meet the criteria.
have passed
Mm-hmm.
and numerous events have unfolded. While the public may have moved past the initial shock, revisiting that moment reveals a striking contrast. Unlike in November, where they simply notified ADOR of contract termination, they now explicitly stated they would never return to ADOR regardless of the trial's outcome. This means that even if they lose the main lawsuit and must pay penalties or face indirect enforcement fines, they have no intention of staying at ADOR. Their legal strategy now aims to convince the court that since they will never return anyway, there is no reason to ban their entertainment activities, and that the injunction should be dismissed.
What?
2. Shift in their legal
What kind of logic is that? That don't
Mm.
make no sense.
argument. During the press conference, NewJeans asserted, "Well, we did nothing wrong, and our contract was automatically terminated." However, they have since moderated their stance, shifting to a more realistic legal approach. Unlike the confident declarations at the press conference, their tone in court was more calculated and pragmatic. Instead of focusing on ADOR's contract violations, they emphasized their irreparable separation from ADORI. This shift made it unnecessary for the court to further examine their intention for the contract termination, allowing them to focus on the legitimacy of ADOR's injunction request. 3. A more strategic and legal approach. NewJeans now must win the injunction case at all costs, which explains their strategic shift. Their legal team, Sejong Shin and Kim, is likely presenting alternative arguments, such as the possibility of compensating the company financially even if they lose the main lawsuit. This suggests that they have prepared legal arguments to justify their actions
Oh.
regardless of the trial's outcome. 4. Active participation in legal proceedings. Previously, NewJeans downplayed the
Mm.
need for legal proceedings, but now all members attended court and actively participated, even though attendance was not mandatory. Their presence and serious engagement indicate a significant shift in their stance over the past few months. 5.
Huh.
Conclusion. A
I feel
shift towards
like I feel like it's important for them to show up, you know. It matters. The case matters and what they said matter. I don't know how it's not in their best interest not to be in court.
Mm.
legal realism. Compared to their unusual and aggressive claims during the November press conference, NewJeans now appears to be following formal legal procedures more carefully. Their shift in strategy reflects an effort to strengthen their chances in the injunction case, indicating a more legally sound and calculated approach moving forward. Part 2.
So, based on the part one, kind of seems that NewJeans is actually doing good. Like,
Mm-hmm.
seems like they're, in terms of legalese, they're better than, like, they're more realistic and more prepared for court than they were before. So
Mm-hmm.
that's interesting. That's not what I kind of thought based on what we have heard. Okay.
An inevitable choice, confronting the tampering allegations head on. During the hearing, NewJeans members strongly asserted that they are one team with Min Hee-jin and must stay together. Among the 5 members, 3 emphasized this point in different ways during their limited speaking opportunities. This marks a further escalation from their stance during the November press conference, where they remained somewhat ambiguous about their future with Min Hee-jin. 1. Cautious approach at the press conference. At the November press conference, a reporter asked, "Will you continue working with Min Hee-jin?" Minji responded, "We haven't spoken with her about it, so we don't know, but we believe she would want to stay with us." At the time, Minji deliberately smiled and responded in a
Do
relaxed
you
manner,
think why do you
avoiding a
think
direct
that's
answer.
relevant to this trial?
Because the Hybe is like suing Min Hee-jin, no, ADOR suing Min Hee-jin separately, and they make it clear that's not happening. Like, under no circumstances that Min Hee-jin is coming back.
Mm.
Legally, NewJeans maintained that they were only leaving the company because their demands for correction were not met, and had no official discussions with Min Hee-jin regarding contract termination. This approach allowed them to keep their legal stance neutral, while still giving fans hope that they would reunite with Min Hee-jin. 2. A clear stance in court. However, in the recent hearing, their position was much more definitive. 3 out of 5 members explicitly stated that they cannot exist without Min Hee-jin. Their argument went beyond merely losing an ideal work environment within ADOR. Instead, they essentially declared, We left because we want to stay with Hee-jin, and we will continue working with her. This shift in tone suggests not just dissatisfaction with ADOR, but an active intent to stay with Hee-jin moving forward. 3. From indirect hints to direct declarations. This change in messaging was gradual
That
in the
helps
past
them
few months.
too, because then they could turn around and say, "Oh, Minnie just made us do it."
Listen, I did say Stockholm syndrome. That's one of
Mhm.
the defenses I would claim, but it's after this court hearing, I would have a hard time believing that.
Mhm.
Making it less immediately noticeable. However, from a strategic perspective, it indicates a move away from indirect hints to a direct declaration of loyalty to Hee-jin. A shift in strategy following Dispatch's report on tampering allegations involving Dabo Link. Initially, they may have wanted to avoid openly addressing tampering suspicions. However, as public scrutiny increased, they had no choice but to face it head on. Rather than denying the accusations, their response in court suggested
No, it's interesting. Why does he keep putting anime over him? Look,
they had no choice but to face
this
it
is the
head on.
second time I see
Rather
it.
than denying the accusations,
Why?
their response
I
in court
didn't notice
suggested,
that.
yes, we left for Hee-jin and we will continue working with her. 4. A pre-planned legal and PR strategy. Considering the circumstances, it's likely that the members' statements in court were not spontaneous but carefully planned. If 3 out of 5 members emphasize Hee-jin within their limited speaking time, it suggests that this was a deliberate message coordinated with their legal and PR teams. This raises
What's more interesting is the two that didn't. Does that mean that the two are kind of like more willing to come back to ADOR, kind of like with the 50-50, where if you have one member
One
remaining,
member.
so would that be like two member come back?
Mm.
Because if worse comes to worse, for them it's okay. They have to pay the money to hide.
Mhm.
2 girls, like 3 girls might be, I don't give a fuck, sue me, or like I have the money, I'll pay. 2 girls might be like, okay, I can't afford it, I need the money, I'll come back. That's interesting.
the question who advised or orchestrated these statements. 5. Hee-jin's production, Sejong's direction, NewJeans' performance. Listening to NewJeans' statements in court, one might feel as though Hee-jin produced the narrative, Sejong directed the legal argument, and NewJeans performed it. This is not just speculation, but an indication that their legal and media strategies have been carefully aligned. Their court statements strategically supported their legal case, while also appealing to fans and the public. 6. Implications for the trial's future. NewJeans' latest stance will likely become more concrete in upcoming trials as they further shape their legal arguments. Be a crucial factor in their defense against tampering allegations. Require additional strategic statements to sustain their legal position. Their clear alignment with Hee-jin means the case is no longer just about contractual disputes, but also potential tampering and intellectual property issues. The direction of their argument will be critical in the next phase of the trial. Part 3. Favorable case structure for artists and Kim and Chang's defense strategy.
Well, that's interesting. Like, so far, it seems like NewJeans is kind of...
They're like got their things together. They don't
Yeah.
look like childish.
That is not what we got at all from earlier.
Mhm.
Wow. Okay.
For the provisional injunction to be granted, 2 main conditions must be met. Number 1, existence of the right to be preserved. Number 2, necessity of preservation. Kim and Chang focus 90% of their strategy on proving the first condition because if the existence of the right is not sufficiently proven, the court won't even consider the necessity of preservation, leading to dismissal. In this hearing, ADOR's arguments significantly strengthened, while NewJeans' key evidence, the ignore them incident, the New Alu document, lost credibility. This shift puts NewJeans at a disadvantage in proving their contractual termination was justified, thus existence of the right to be preserved.
Okay, so...
We're in the thick of it now.
yeah, now... okay, this is getting a little confusing.
If this condition is not met, the injunction request is immediately dismissed. ADOR's counter-arguments successfully weakened NewJeans' key evidence, making it harder for them to prove contractual violations. NewJeans' claim of systematic exclusion within HYBE lost significant ground. 2. Necessity of preservation. Difficult argument to make. Emphasizing preservation too strongly could backfire by making it seem like the relationship is already broken beyond repair. ADOR must avoid directly attacking NewJeans while convincing the court that dismissing the injunction would cause irreversible damage to the company. Key challenge show that even if NewJeans compensates ADOR financially, the damages cannot be fully repaired. 3. Kim and Chang's defense strategy.
Wait, what? Even if NewJeans compensate ADOR financial damages cannot be fully repaired. So what? So what do you want?
I think, I wouldn't be surprised if they told the girls you have to apologize.
So that's what... Oh, like basically saying the public perception damage?
Yeah.
Oh.
Like, what did you make ADOR look like? What did you make HYBE look like?
Okay, I can see that.
What about
Kim
for
and
the
Chang
future? Like, will future artists be even interested to come into this mess? You made us look so messy.
I can see it, okay.
Structure their argument carefully to undermine NewJeans' claims without appearing aggressive. Separate emotional narratives from legal facts. Ensure the court has a logical path to dismiss the injunction. Their strategy focused on framing this as a case about industry standards, not just a dispute between ADOR and NewJeans. Presenting ADOR as being willing and able to continue supporting NewJeans if they return. Arguing that the group's concerns are exaggerated and legally protected. 4 courtroom advantage shifts to ADOR. Kim and Chang successfully created a structured, rational argument. NewJeans' key pieces of evidence lost credibility, weakening their case. The case now centers on whether NewJeans' departure was legally justified. If ADOR continues on this trajectory, it strengthens their position for a favorable ruling. I believe this hearing showed ADOR gaining the upper hand, forcing NewJeans to restructure their arguments for the next phase of the trial. Part 4. Hanni's testimony in the National Assembly. What's the truth? One of the biggest issues in NewJeans' contract termination claims was Hanni's testimony in the National Assembly, particularly regarding the ignore them incident. During the hearing, NewJeans' legal team submitted Kakao Talk messages between Hanni and Min Hee-jin as evidence. However, instead of supporting NewJeans' argument, this evidence actually weakens their case. When with the Kakao Talk messages revealed. In the chat logs, Hanni never explicitly says she heard ignore them. Instead, she says, I'm not sure what the manager said exactly. Min Hee-jin then leads the conversation asking, so the manager instructed ILIT members not to greet you? To which Hanni responds,
So basically, he's saying Min Hee-jin kind of led her to that.
vaguely,
She
saying
knows
she
what
doesn't
she's
know.
doing.
This contradicts Hanni's
The
public
puppet
claims
master.
that she clearly heard the directive to ignore them. Two key facts revealed in court. Hanni never actually heard the phrase ignore them. This wording was first introduced.
So it's interesting. I wonder if this could create a perjury charge. I don't know how perjury works in South Korea, but she did perjure herself on the stand in front of National Assembly. Then
Did she, or
Yeah,
was
she
she
did.
coached?
she doesn't matter. She
Manipulated
said
to say
I
that.
heard ignore them, whereas previously she admits I didn't actually hear that. That's perjury. Now, the thing with perjury is it's not like, at least in the States, it's not really like often like people are prosecuted for it, but it could be. So like, would they prosecute her for that? And do the laws work the same way how I do in the States?
Introduced by Min Hee-jin, not Hanni. Hanni initially admitted she was unsure what was said. Hanni did not perceive the incident as harassment or bullying. In the messages, Hanni says she understood why ILIT acted the way they did. She even describes the situation as almost funny, showing she did not interpret it as intentional exclusion orchestrated by any level of Hive's organization. 3. The legal problem with Hanni's testimony. In the National Assembly, Hanni firmly stated she heard ignore them, but the Kakao Talk messages show that she wasn't sure what was said at the time. This raises concerns that her testimony exaggerated or distorted events. This contradiction damages the credibility of NewJeans' claims. If the court sees this as a misleading testimony,
why did she go in front of the assembly with confidence to say that?
I think they didn't expect it would go to courts like that.
That they will have copy of the text message communications?
I think they just didn't see it going to courts. I think they thought, they would kind of like, in their mind, for whatever reason, I think they really thought Hype would just let them go. I don't know why they would think that. Maybe Min Hee-jin like kind of bullshitted them into it. I really believe that's what they were thinking. Oh, we'll just walk.
it could seriously weaken their case. For another perspective, was there an intentional misunderstanding? Hanni also mentioned she understood why ILIT might feel uncomfortable around NewJeans. Given the public tension between Min Hee-jin and ILIT, it's possible that ILIT members felt awkward interacting with NewJeans. Their manager may have simply advised them to avoid unnecessary interaction rather than deliberately excluding NewJeans. This raises the possibility that the ignore them controversy was a misunderstanding blown out of proportion. 5. Conclusion: the evidence hurts NewJeans' case. The Kakao Talk messages do not support Hanni's National Assembly claims. They actually prove that her statements changed over time. This weakens the narrative that NewJeans was systematically bullied within Hybe. As a result, NewJeans' argument for contract termination loses credibility. ADOR's position in court strengthens significantly. NewJeans must find a new legal strategy to justify their claims. This revelation shifts momentum in ADOR's favor, putting NewJeans in a difficult legal position moving forward. Part 5, abandon New RO and start over. The debate over Hybe's
New R, dog. I don't think we saw this. I don't know what New R is.
internal report. A major point of contention in this hearing was Hybe's internal document. NewJeans and ADOR presented conflicting interpretations of the Naiwaru reference in the document. One NewJeans argument.
Where do you see
New-aru
that
means
word? Oh, new R.
Yeah, New R.
Oh.
Hybe was planning to exclude new NewJeans from their girl group strategy. Hybe was systematically trying to contain or stifle NewJeans and restructure its girl group lineup. To ADOR's rebuttal.
We
R
did
in
hear about this. Remember? And one of the letters was supposed to stand for NewJeans.
I do remember hearing about it, but we haven't heard it like about it being talked in the courts. We only heard about it like earlier, like a couple months ago.
Or refers to IVE, not ILIT. At the time of the document's creation, ILIT hadn't even debuted yet. NewJeans' exclusion is a misinterpretation. The report was categorizing fourth-generation girl groups alongside competitors like Blackpink, aespa, and EVE. 3. NewJeans' counterargument. Hybe deliberately removed NewJeans from the fourth-generation representative girl group category while including LeSSERAFIM. Hybe launched ILIT as a copy of NewJeans to devalue their brand and replace them. 4. ADOR's final response. The report author was not a decision-maker. This was just one person's opinion. This document was not an official Hybe directive. Between May 2023 and October 2024, Min Hee-jin herself accessed this document more than 7 times. It's misleading to claim it as proof of a conspiracy. 5. The core issue. The newer document's meaning, a critical development in this trial, NewJeans lawyers say Jung effectively admitted that R refers to Ivan, not Illit. Why is this significant? NewJeans had argued that Hybe planned to replace them with Illit. If R actually refers to Ive, then their core argument collapses. There is no direct evidence that Hybe was planning NewJeans'
R stands for
exclusion.
I've.
6. NewJeans' strategic retreat. Since their original claim lost credibility, they shifted to a new argument. Hybe intentionally excluded NewJeans from the 4th generation category. However, this claim is more of a marketing issue than a legal contract violation. Is unlikely to justify contract termination in court. 7. The court's
The R thing, I think, I don't know how, but that's what he's saying. We have to, maybe something lost in translation. I can't. This one is a little hard to understand
Yeah,
because
but the different phrase that was used before where I get it, I got it. It was like new something that incorporated everyone's initials. And then we heard like something like cat's eye in the lineup.
I don't know. This one is a little difficult to understand because also he removed the captions that he had go. Because I would read those captions that he kind of like showed. It's a little hard.
doubts about NewJeans' case. At the end of the hearing, the court asked NewJeans' lawyers to resubmit their contract termination reasons. What does this mean? Courts only ask for revisions when a claim is losing credibility. Sometimes this suggests the judge found ADOR's arguments more persuasive. NewJeans must now
Wow, we didn't know that they basically asked to resubmit the what's your reasons for contract. So
modify or abandon some of their legal arguments. 8. Future outlook Kim and Chang's next move. If the court continues questioning the newer document, ADOR's legal team will likely argue that the document was not about removing NewJeans, but about overall strategic planning. Present additional evidence proving Hybe's long-term support for NewJeans. Undermine claims that Hybe was actively working against the group. On conclusion, ADOR gains the upper hand. NewJeans' key claim about Newer lost credibility. Hybe's alleged plan to push out NewJeans lacks evidence. ADOR successfully shifted the narrative to NewJeans' misinterpretation of an internal document. NewJeans now faces the challenge of rebuilding their legal argument. As a result, this hearing strengthened ADOR's legal position, while forcing NewJeans to rethink their approach. Part 6. Proving the right to be preserved and necessity of preservation. A legal and strategic battle. For the court to grant a provisional injunction, 2 key conditions must be met. One, existence of the right to be preserved, 2, necessity of preservation. In this hearing, Kim and Chang focused over 90% of their efforts on proving the first condition. If they failed to establish the existence of the right, the court wouldn't even consider the necessity of preservation, leading to an immediate dismissal of the injunction request. Upon proving the necessity of preservation, delicate balance. If the existence of the right is only 70% established, the court won't even reach the second condition. But if the first condition is over 90% proven, then demonstrating preservation necessity becomes easier. The risk, if ADOR pushes too hard, it could backfire by making it seem like the relationship is already beyond repair, which could justify NewJeans' departure. ADOR needs to prove potential damages without directly attacking NewJeans. This requires a carefully crafted legal argument, balancing facts with strategic persuasion. 2. Kim and Chang's legal strategy.
Wow, that's very interesting. So it's like really you gotta tiptoe around it. You can't like attack the girls. I mean, I would think you can attack Min Hee-jin though.
She's not a member.
Yeah, she's not. Oh, unless she is the 6th member. But yeah, I think you could go at Min Hee-jin, but not. Yeah, you can't really like attack the girls. You kind of have to show the love for the girls. But very interesting, huh?
Strategy on preservation necessity. Kim and Chang structured their argument around 4 key points. 1. Impact on the K-pop industry. If the injunction is denied, it could negatively affect the entire K-pop industry.
Agreed.
This case sets an important precedent for contract stability in the entertainment business.
Yeah.
2. ADOR's willingness to support NewJeans. If NewJeans returns, ADOR is fully prepared to continue supporting their activities.
Oh, okay.
The company has all necessary resources ready for their comeback. 3. Injunction wouldn't harm NewJeans' rights. NewJeans' concerns are exaggerated, and they still have legal protections. 4. Link to tampering allegations. NewJeans publicly mentioned. A new stage name. Plans for large-scale overseas concerts. A new agency. These statements raise concerns about potential tampering, making this case about more than just a contract dispute. 3. Kim and Chang's tactical use of evidence. ADOR needed to argue that even if NewJeans was willing to pay penalties, the damage to ADOR would still be irreversible. However, there is no Supreme Court precedent directly supporting their position. Instead, Kim and Chang cited legal practice guidelines issued by the court, using it as a secondary reference for the real issue to tampering and IP violations. ADOR strategically framed this as not just a contract dispute, but a potential tampering and IP theft case. If NewJeans fully separates from ADOR, can they still use the name NewJeans, the NWJNS trademark, the Bunnies fandom identity and associated branding? Kim and Chang argued. ADOR built these brand assets, and NewJeans cannot take them elsewhere. The group's planned overseas activities could violate these rights. This is a critical point. ADOR isn't just trying to win this case. They are laying the groundwork for future lawsuits over IP rights if NewJeans leaves. 5. For the court's next steps and expected ruling. The judge asked NewJeans' legal team to resubmit their contract termination reasons, suggesting the court might have found weaknesses in their original arguments. NewJeans must either revise or abandon some of their claims. Kim and Chang successfully shifted the case from an emotional dispute to a structured legal debate. If ADOR continues this strategy, their chances of a favorable ruling increase. 6. Conclusion. ADOR takes the advantage. NewJeans' main arguments lost credibility, especially the ignore them and Newer incidents. Kim and Chang crafted a precise legal strategy without openly attacking NewJeans.
It's not New R. It's New Ali. I think because now we saw New Ali.
Can you go back to it?
You see New Ali.
Mm-hmm.
So I think Lee is Le Seraphim and New is NewJeans and A is Ive. I think it's the way you pronounce or spell them in Korean and how it's translated to English.
Jeans. The case now focuses on industry standards, tampering allegations, and IP rights. Final takeaway. If ADOR's arguments hold, the court may reject the injunction, forcing NewJeans to reconsider their legal approach.
NASCAR weekend at Homestead Miami
Very
Speedway.
interesting.
Get your tickets now at
Can I see the comments for this one?
homesteadmiamispeedway.com.
Yeah, but I don't think we're
Running
done.
a small business? Create your invoices at skynova.com. Easy, but professional.
Part 7. Min Hee-jin's direction, Sejong's production, and Hanni's performance. A Rashomon-like legal drama. In the latest hearing, Kakao Talk conversations between Min Hee-jin and Hanni were disclosed. These messages undermine NewJeans' claim that the conflict was a systematic bullying case planned by Hybe. Instead, they suggest that Hanni played a key role in building Min Hee-jin's legal strategy that ultimately led to conflicting statements in the National Assembly. One, the ignore them, controversy memory versus reality. Until now, many assumed Hanni at least genuinely believed she heard ignore them. However, the Kakao Talk
Yeah.
messages show that
That is very true. We kind of assumed she heard that, but we felt it wasn't a big deal. But we did believe her. Now we don't believe her at all. Period. She contradicted herself.
Hanni initially had no
Not
memory
only contradicted, she perjured herself.
of hearing it. If she didn't hear it at first, but later testified with certainty, it suggests
And
the statement
frankly, she's an immigrant, right? So if she gets committed of any crime, her visa's gonna get revoked and she's gonna get deported. So, if Hybe really wanted to be petty or whoever, they just go after the perjury charge, and she's gone.
And it kind of shows how Min Hee-jin is willing to get a narrative that fits.
Put other people under
Yeah.
the bus. Yeah.
uh-huh.
was not just a misunderstanding, but was actively reframed. Two surprising fan reactions. Some fans still defend Hanni despite the evidence. But based on the revealed facts, it's difficult to see her statements as a simple mistake. If anything, defending her would require arguing that she was manipulated into believing it essentially a gaslighting victim. However,
Yes, Stockholm syndrome, what we've been saying, which
Mhm.
I wouldn't put past it. That's what I would do if I was the girls.
I do not personally believe this interpretation holds. 3. Rashomon and the manipulation of truth. This case
Oh, so you
resembles the
don't believe it.
1951 Japanese film Rashomon, in which different people recall the same event in completely different ways. Memories reshape to fit personal interests. The truth remains unchanged, but how it is told and perceived can be altered. In this case, Hanni never initially heard ignore them. She didn't interpret the situation as bullying. Yet, by the time she spoke in the National Assembly, her narrative had shifted into a clear accusation. Without NewJeans' own evidence submission, this story might have remained fact in court. 4. Who is really the victim here? Some
True.
questioned whether my stance was biased against Hanni, or whether I saw the manager as the true victim. My position: the issue is not about who is weaker, but about the consequences of false narratives. Lies that harm others should not be justified. The manager in question could legally claim defamation based on this case. At a minimum, Hanni should
Oh, the manager could claim defamation. So honestly, even Hype don't have to proceed with perjury. The damager could sue. Although I don't know if defamation is criminal or civil though there in Korea.
apologize to Illit and the manager for the strange legal strategy of Sejong. As a lawyer,
Well,
I
yeah,
find Sejong's
because imagine they even requested a whole apology.
Yeah. Yeah.
They're trying to
legal
flex
strategy
power
puzzling.
here.
Instead of strengthening NewJeans' case, they submitted evidence that weakened it. This led to Hanni's National Assembly testimony being debunked. NewJeans' core arguments losing strength. At this point, it almost seems like Sejong's strategy is hurting NewJeans more than helping them. 6. Final thoughts: the future of this case. I oppose unrealistic moral standards for celebrities, but false testimonies that harm others should be held accountable. If Hanni takes responsibility, reflects, and
I want to
apologizes,
see the comment.
public opinion may soften. The NewJeans fandom must now decide: 1. Ignore this issue and move forward. 2. Acknowledge the truth and prevent similar cases in the
Hanni,
future. I
she
believe
came out. Honey, she came out and said, "You guys are twisting my words." So I don't think she's in the position to want to apologize.
Let's see. Given that Hanni has been found to have lied, deliberately manipulated the public narrative, does that constitute grounds for deportation under relevant immigration laws? Considering for well, I guess we'll see how he answers. Considering the public shaming inflicted by NewJeans, Hanni, can a former Lyft employee pursue legal action for emotional
That's what
distress?
I'm thinking.
He says she could. Can the former Lyft employee use the evidence presented in court as his her evidence of Hanni's lies? Where is the author's response? Why is it not the main one? Oh, there you go. I don't think Hanni could be deported as a result of this incident. This remains a civil matter in regulation. Yeah, that's what I kind of was going to say. I think that itself is not criminal. The only thing that's criminal to me is perjury, but I don't know how that works in Korea. Moreover, even based on ADOR's publicly stated position, I believe ADOR would not want to Hanni deported over this issue either, right?
Yeah. Their goal is to have the
Yeah.
group come back
I think
together.
that would be worse, like if
Yeah.
they're being petty, like if they're losing in court, I think that's what they would do then. On the other hand, theoretically, Alice manager could consider taking legal action on the grounds that Hanni deliberately made false statements.
Cause low key, people started to throw hate at Eyelid.
At
Like,
Eyelid, and the manager, I
yeah,
believe, got fired for that too.
Oh.
However, from a practical standpoint, pursuing such legal action is unlikely. Even if a civil claim for damages were possible, the potential compensation would be minimal, as South Korea does not have a punitive damages system like the US. Oh, okay. Whereas the emotional distress, effort, and cost involved in the process would be significant. Therefore, unless there is a special circumstance, it's unlikely that the manager would take such action. Okay. That being said,
Wow, that's
if
messed up.
if legal proceedings were initiated, the Kakao Talk messages presented in this trial could certainly be used as evidence.
Wow, that's messed up. A
Very
person lost
interesting.
their whole job and you lied?
Yeah. Wow. Wow. Very interesting.
Guys, of course, let us know your thoughts. Are you still a bunny? Let me know if there's still bunnies out here running these streets.
They are, because they went on our Discord trying to push their narrative.
And what's the narrative?
That I don't know. I ignored it.
I need to check it out. Guys, of course, I'll see you in the Discord. Don't forget to like, comment, and subscribe. Join the Discord. And as always, share as much kindness as possible.